You may be seated. Today is the case of Lochner versus New York. Mr. Joseph Lochner, tell me why you're here today. It says here that you are here for violating the Bake Shop Act.
Well, I just don't see how it's fair. It's too social Darwinist to me. It violates my workers' rights.
So you're working more hours than was allowed legally. Let's go over to New York. New York, how do you feel about this?
Well, frankly, Mr. Laissez-faire, I find this whole thing ridiculous.
It's Judge Laissez-faire to you.
Mr. Lochner violated the Bake Shop Act. It's as simple as that. Cuff him.
Only because he won't let me work. This is unreasonable.
I'm just looking out for number one. I got to be on planning.
Calm down, there's no need for that. In the case of Lochner versus New York, you are not going to jail.
Yes!
Mr. Lochner.
I apologize.
It's just hard that I can't control my citizens by limiting how many hours they work and thus how much money they make in order to maintain a rigid social hierarchy that benefits my federal economy.
That's really hard.
Really?
More when we come back. Welcome back. In the case of Unknown Child 1 versus Unknown Child 2, let's get started. Unknown Child 1, please tell me why you're here today.
Well, Unknown Child 2 took my hand after it was severed off by a machine when I was working in the factory.
No, it was you. I literally fell off the machine and you took it.
Do you think that the actual issue stems from you being 8 years old and working over 14 hours a day in extremely harsh working conditions under the freedom of contract law?
No!
Order in my court. Okay, so you think that the issues are caused by the other child and not because of the fact that you're 8 years old and working in a factory that cut off your own hands?
Well, since I'm a part of the poor working class, I don't believe in social Darwinism, and I think that there should be government interference in our long working hours. But really, I just want my hand back since Child 2 took it.
I actually didn't take it, but I know that she took it. I don't know where her hand is.
I just want my hand.
Could this be the hand that you're referring to? Child 1, we've had this hand tested and we've come to the conclusion that this is not your hand. Come back after the break to find out whose hand this really is. Good day. Today we have the case of Adair versus United States. Miss United States, you're charging Adair with violating the Erdman Act as he fired a worker unconstitutionally for joining a union. And Mr. Adair, you claim that your firing of the employee was valid.
Correct, Your Honor. America has overstepped its large enough boundary to determine the legality of my completely legal business contract.
Well, when violating the recently passed Erdman Act, which effectively made it illegal to fire employees for being associated with unions or discriminatory intention.
Where you are the one overstepping my Fifth Amendment right to freely construct contracts with my employees that overrules this so-called lights. Order.
Let me check my records about the Erdman Act. Here it says that it was passed in 1898 and it protects railroad workers from being fired if they joined a union.
Exactly, I'm simply upholding the law.
However, the Fifth Amendment does allow freedom of contract between employer and employee. In the case of America versus Adair, America, you are constitutional.
I told you so.
Thank you for watching Paternity Court.